topic is being brought to you by Tzedek, Small Business Essentials. So today's topic is intellectual property IP for small businesses. Again, my name is Veronica Lopez. I'm a business counselor manager here at Pace Business, and I will be your host. So our featured speaker is Nadia Segura Narvaez. She's Director of Small Business Development Program at Tzedek Legal Services. And before we get started, we'll just do a brief intro that we do for PACE services. So for housekeeping, everyone is in listening mode. We may give you an opportunity to raise your hand if you have a burning question or we just need more information regarding your question. We do encourage you, we're not using the Q&A box today, we're using the chat box. So all questions should be entered in the chat box. We will have various subtopics today. During those subtopics, we'll take a break and be able to answer any questions during that time. So keep the questions coming in the chat box and we'll gather them, and during those break sessions, we'll go ahead and answer any of your questions. Today's webinar is being recorded. It will be available in our e-library, and it will be emailed to all today's attendees, but it does take about 4 hours for Zoom to process it. We also want to encourage you at the end of today's webinar, there's this survey that pops up at the end. We really would like your feedback. You can go ahead and fill that out. So PACE Business Development Center offers multiple services. Just here to name a few. So one-on-one consulting, you can meet with the counselor to cover any area in your business stage from startup or operating to growth. We cover business plan development, legal considerations, and then also we offer an entrepreneurial training program. It's a 10-part series. There is a small fee of $150, but once you complete the course, the funding is reimbursed back to you. And of course, we have our ongoing courses like these and available also in our e-library, the recordings, and then we have continuing live webinars. We offer small business financing from $500 to $350,000 in-house. We also partner with banks and other financial institutions such as CDFIs like PACE to help you prepare or package your loan. And we also offer credit review assistance in various parts to help you prepare the loan. Through our WorkSource Center, they offer employee and hiring assistance. They also offer a program called On-the-Job Training, where they provide 3 to 6 months on-the-job incentive. So that covers half of the employee's salary. If you're interested in the program, please let me know. I can provide a referral to our WorkSource Center. Here are some of our upcoming webinars. So today's webinar is a part of a 4-part series. So the next topic will be Small Business Entity Choice Basics, which is happening May 20th. We encourage all of you to come back to finish the series to get the most out of the full series. And then tomorrow, we're partnering with the Women's Business Center to provide a series on digital marketing for women-owned business, and men, of course, are welcome. You can go ahead and scan the QR code if you're not already signed up for our e-newsletter. So with that, I just want to give an opportunity to introduce our speaker for today. So Nadia Segura is the Director of the Small Business Development Program at Tzedek Legal Services. She's the directing attorney of the program. Through her role, Nadia leads a diverse and dynamic legal team that provides free legal services to low to moderate income small business owners and entrepreneurs with a focus on women, disabled, veteran, immigrant, limited English speaking, LGBTQ, and BIPOC business owners. Nadia received a Master's of Laws from Columbia Law School, where she earned the Parker School Recognition of Achievement in International and Comparative Law. She is admitted to practice law in California, New York, and Mexico. I'm sorry. Yes. With that, I just give a warm welcome to Nadia. And with that, I'm going to give Nadia an opportunity to share her screen. And yeah, the stage is yours, Nadia.
Can you see my screen now?
Yes, I can see it.
Okay, great. Thank you so much, Veronica. And hi, everyone. We are very happy to be here. We wanted to start just by saying thank you to Pace for this partnership. I already put on the chat the link to our application. We will go be like I will be sharing how you can reach out to us. And then, as Veronica said, we have different sections to this presentation, so I will make in pauses to answer any questions that you may have throughout the presentation. So I'm going to start just by sharing a little bit about Tzedek, the organization I'm representing today. Tzedek is a legal aid nonprofit. We've been in the community for over 50 years, and we provide free legal services to individuals in LA County. And the services are provided regardless of an individual's race, religion, ethnicity, or immigration status. We will talk in specific today about our small business program. So the small business program at Tzedek is designed to help low to moderate income entrepreneurs and small business owners. And we do that through different, I would say, areas or buckets of work. The first two, the community presentations and legal academies, focus on providing community presentations like these ones on topics that are relevant for the community. We have, as Veronica mentioned, some other webinars coming up with Pace, and then we do webinars with other community partners, so you can always register for those in our website. We also have guides and other free resources available on our site, and those resources are available in different languages, and we also have direct client representation. For direct client representation, we focus in a specific on transactional law. What that means is that we can help small businesses with everything before the matter goes to litigation. And that can be incorporating an entity, answering questions regarding contracts, helping you draft a contract for your business. Today we're going to talk about intellectual property, so we can help you register a trademark, a copyright, or answer any general questions about intellectual property protection. We are also the organization has a history of protecting low wage workers. So for us, through the Small Business Development Project, it's very important that small business owners comply with all employment law regulations. So we can help you with that too, and we can help you draft appropriate employment law agreements. Uh, to be able to get access to our services, we ask you to please complete the online application that I put on the chat. That's the first step to reach out to us. And as I have mentioned before, we have this partnership with Pace. So whenever you are coming to reach out to us, please include that you were referred by Pace so we can track that number and give priority to your application. We also am including there the website through to our organization, and there you can register for upcoming webinars and access the free resources that we have available. Um, so before we start, I want to read this disclaimer, and what it says is that the information that we are sharing with you today is intended to assist in exploring legal issues relevant to small businesses in California. There are many factors to be considered to determine what is the best course of action for your business and your case. And the presentation today is only focused on the most important factors. So what we are sharing today is for educational purposes only and is not intended to represent legal advice. The questions that I will be answering throughout the presentation are general questions, I will say. If I think that your question will be better addressed in a one-to-one consultation, I will let you know. You should decide what is the best course of action for your business after discussing your specific case with an attorney. And as I said, I left already on the chat the application for our services. So if you have specific questions about your business or your intellectual property, you can reach out to us by completing that online application. So I'm gonna start, and I know that we already asked some questions on the chat. I see that we are a big group, but it will be very beneficial if people can start writing whether they had already registered a trademark for their name or if they did any research before they selected the name of their business. If you can start putting that information on the chat, I think that will be helpful. Um, okay, so the first topic that we want to discuss is what are the benefits of registering your intellectual property. As I said, a lot of the times when we talk with small business owners, they think that intellectual property protection is something that might be difficult or is outside of what they can do. They think that this is complicated, and they don't think about protecting their intellectual property. Your intellectual property can become one of the most important assets of your business. The benefits of registering your intellectual property include exclusive rights, meaning that you will have the exclusive right to use, for example, your business name or the logo that you had created for your business. Competitive advantage: protecting your intellectual property can provide a unique selling point and differentiate your business from other competitors. Brand reputation: as you continue working on your business and you continue investing in your business, you may be able to create a reputation, and having a name that is protected and that cannot be in some way taken by someone else will strengthen that brand reputation that you have. And then it can increase your business value. I know that we have a lot of businesses here, and I'm sure you are not thinking about selling your business at this time, but there are occasions in which we have seen transactions of people that maybe are ready to retire and they are selling their business, or they are moving to another state or somewhere else, and they want to sell their business. And because they didn't invest on intellectual property protections for their business, sometimes those transactions don't come up. So protecting your intellectual property can increase the value that your business may have. The other issues that I think are important regarding intellectual property is that you are gonna have, I heard, upcoming a session about another class about about marketing, and they will tell you a lot of different tips, I'm sure, on how to market your business. We live in an era where a lot of the businesses are sharing information on social media as a way to promote their businesses. One of the main risks that we see with a lot of small business owners is that they don't do the appropriate research before starting to use either their brand name or their logo. And then with time, they receive letters from competitors saying like, hey, you're using the same name I have for my business. And sometimes those businesses might not be established here in California. There might be somewhere else. And an issue with that is that a lot of costs can be incurred if you are breaching someone else's name or trademark or other type of intellectual property, and not knowing that you are breaching is not an excuse to for the law to protect you if you didn't do the appropriate research. So if we have a lot of entrepreneurs right now, as you're thinking about your business name and how are you going to establish your business, it's important that you do the appropriate research. As I was sharing, some of the risk of not protecting your intellectual property, it includes legal disputes when you are reaching someone else's intellectual property, loss of market share, competitors may copy or imitate your products. We had a business coming up to us. It was a taco stand, and they have been using the same name for a long time. They were becoming very, very popular. And apparently someone else opened another taco stand very close, a couple of blocks away, with a very, very similar name. They hadn't protected their name at the time, and they were like, we're starting to have less customers because they think we're the same people as the other taco stand that opened with our same name, and those tacos are not that good. So they were having this issue of losing people because they were being confused. But the most important, they were affecting their reputation that they have. So we're talking now about two of those risks that we are mentioning. So that's why it's very important to protect your intellectual property. Also, miss opportunities, as I said with the other case of that company that was ready to sell their business, and they weren't able to do it because they didn't have the appropriate intellectual property protections, and the other party that was interested in buying from them didn't decided to go through that transaction because the intellectual property was not protected. Okay, I see people are saying that their business is already protected. I'm happy to hear that. I'm gonna go to the next slide. So what are the steps to protect your intellectual property? First of all, I think the most important step is to identify all the IP assets that might be important and that are that could benefit your business from being protected, and that can start with your business name, that can continue with the specific logo that you created for your trademark. We also work with a lot of small businesses that, for example, are creating products that, well, not products, but like different like books or photographs that can be protected. So creating an inventory of the things that you think are important for your business and that you want to protect. Research and register. Once you have the specific assets, as I said, it's very important that you start that research process to make sure that they are actually unique, that you are not breaching someone else's intellectual property, and that you understand the process and the things that you need to be able to register that intellectual property. Taking appropriate confidentiality measures. A lot of the times, and you will see throughout the presentation, there is a type of intellectual property in which you actually don't have to go to register to a government agency. It is more about keeping the secret. So making sure that if you have any specific assets that you want to protect, you have the appropriate confidentiality agreements and measures in place so you avoid other people stealing that intellectual property for you. And that can be something as simple as having an NDA, a non-disclosure agreement, when you are talking with other partners about ideas that you want to do with them, about things that are relevant for your business and that nobody else knows. It might be important that you have that. Also, even we see businesses that are just starting and they are looking for investors, and they go and start sharing their ideas without having anything in writing, without knowing that by not having something in writing, their ideas and the information that they are sharing might be at risk. And then monitoring and enforcing. It is very important that once you have protected your intellectual property, you take the appropriate steps to avoid other people from copying it, that you enforce the rights that you have. Because if you don't do it, sometimes some federal agencies might consider that as you dropping your intellectual property or not being interested in continue having it protected. And then educating the employees. I think that is related at the end with confidentiality measures, making sure that your employees know the importance of the intellectual property, signing those NDAs even sometimes with your specific employees. And when they are going out there, for example, looking for investors or sharing some projects or ideas, making sure that your employees know that, for example, it might be important that if they are talking with another party, they sign the appropriate NDA before disclosing confidential information that might be protected under intellectual property. I'm going to start now with the different types of intellectual property. This is a summary of all the different areas that we are going to discuss today. But before we start, I want to know if anyone has questions that you would like to bring up before we go through each of the different areas that are protected under intellectual property. No questions? I don't see any questions on the chat. Okay, so I'm gonna start. As you can see from the screen, we have four main groups of areas of intellectual property that are protected. The first one is copyrights, the second one is trademarks, trade secrets, and patents. I'm gonna start discussing each of them, and I will say that if you have specific questions related to your business or to the intellectual property that you wanna protect, you can always reach out to us. So the first group that we are gonna discuss today is trademark law. I'm just gonna go through all these because we have a lot that we wanted to. We're showing you the different trademarks that can be protected. So what is a trademark? A trademark is a type of registration under intellectual property law that protects other individuals or other businesses from using it. There are different types of trademarks. The first ones are words, symbols, colors, or sounds. All of them can be registered. And what is important, and as we will discuss, all of these ones can be registered under different classes. So let me go to the next slide. But these are just examples of popular trademarks that had been already registered. Okay. So the trademarks indicate the different types of protection under trademarks. Basically, all of them indicate the source of goods, or the service marks indicate the source of the services. They are trying to differentiate your business goods, or the goods that you are selling, and the services that you provide from others. It's a way to differentiate from them. There are also collective marks and certification marks that sometimes can help. You may have your business, but you may be part of a collective mark and can give added value to your business. I'm gonna go to the next one. And then sometimes, as it says there, domain names can be considered trademarks. However, they should like follow certain information to be able to be protected. So what is important when you are choosing a trademark? The most important thing that you should consider as you are going through the trademarks is how distinctive it is from other trademarks that might be available. And as I'm going to explain, there are different types of classes or groups under which you can register a trademark. So there might be that there's a trademark already registered with a similar name on a different class that, for example, is selling products related to books. And your trademark is a restaurant. So it is okay if somebody has that trademark registered only on their books, and you're trying to register your trademark under the class of a restaurant, because they are not competing directly. So you want to make sure that your trademark is very different or has this distinctiveness on the group or the class that you want to register it. So it is important that it is also not something that is just descriptive, that is not generic, that is not arbitrary. What you, as I said, want to make sure is that it's distinctive from the rest of the trademarks registered under that specific class. I'm gonna go to the next one. Okay. So what are some of the steps that we recommend for you to follow once you are registering a trademark? First of all, to search for prior use. There are different ways in which you can do this search to make sure that the trademark that you are interested in protecting is not being used by someone else. The first one is the search through the test system or the USPTO. It is actually very easy to do, and it will show you where there are any trademarks registered under that specific class that you're looking for. Also search domain names if you intend to register a website. Do a Google search or another type of, I would say that the Google search is the easier, but also like we right now are recommending clients, for example, to also look on social media, on Facebook, on different platforms to make sure that the trademark is available. So that's the first step, to make sure that you do that search before you start investing on like resources on protecting that trademark. Okay. Let me go through the next one. I see that people are starting to have questions. I'm happy to answer all the questions regarding trademarks once I'm done with this specific section, which will be like within the next 3 slides or so. So you can write your questions and I will answer them as we are going through the slides. So it is important to truly research your mark in the different test systems that I mentioned with the USPTO. You can reach out to the office and we will be happy to schedule a consultation with you to walk you through that specific search. There are also some other platforms that sometimes may charge you a small fee, but might be able to help you to do that search for you to make sure that you are doing the appropriate research before you are investing on your trademark. The other important thing that is important related to trademarks is whether you are going to use that trademark only in the state of California, or if you are planning to sell products or offer your services outside the state of California, because that will impact whether you want to register the trademark only in the state of California, which might be cheaper, or you might want to register in the federal level through the USPTO, which is called the agency. And that will need that you prove that you are actually selling those products or offering those services outside the state of California. What they call it is that you are crossing the commercial lines among states. Okay, I'm gonna go to the next one. So what are the steps for trademark registration? As I said, there are two different ways in which you can register your trademark. One of them is through federal registration or state registration. Registration is not required. However, if you register, it will give you the possibility of actually being able to ask other people to stop using your trademark. We recommend people that decide not to protect to invest on the registration to keep track of when they started to actually use that trademark. We have recently a client, for example, that had been operating since I think it was like 1995. They had never registered the trademark. However, they had a lot of newspaper articles and other photos that had dates and other ways to prove that they actually been using the trademark for a long time. So even though they did the registration until now, they were able to prove that the first use of that trademark was older. So if you decide not to register at this time because of the investment that it might require, we recommend you that you keep track of when you started to use it in case it is needed in the future. So registration is also available in the federal level if the trademark is already being used or if you plan to start using the trademark. So there is a specific type of registration that is an intent to use, meaning you are kind of separating that trademark, but you will need to show that you are using it within the specific period of time that the USPTO requires. Then for state registration is the same way. It is not a requirement, however, it gives you certain rights, including taking somebody else to court if they infringe your trademark if you register it. And as I said, with the state registration, it is limited to services or products that are being sold within the state of California. The difference between the two of them, and it's something that we talk with clients when they come to the office, is whether you are actually in your business plan, it is included to expand your business outside of the state of California. Because the investment to actually apply for the trademark and then renew it can be higher if you are registered in the federal level. So that's why a lot of small businesses start with just registering in the state of California if they are not thinking to go outside, and then in the future they can go ahead and get the registration for the federal level. So this is this is the end of the portion regarding trademarks. I see that somebody had questions, so I don't know.
We have one question for Noemi. I think she wants to be allowed to talk. Uh, is that okay?
Yeah, that's okay.
Okay.
Go ahead, Noemi. I can't hear you.
Oh, I can't hear her either. Okay, well, there was another question while we get Noemi back. From
Yeah,
Chris
I see
Harris. Yeah.
that. Yeah, I see another question that is, if I plan to use my trademark, such as my domain name from my website, it is also important to make sure that actually that domain name is available. So it's a different search, like on the trademark, but also on the domain name level. To sell my services globally, do I need to register in both California and the USPTO? So if you are already planning to sell your products or offer your services outside California, the USPTO will cover. So you can just go ahead and directly apply for the USPTO. Again, as part of the registration process, they will ask you to show that you are already either using the trademark and that you have already had operations outside the state of California. So you need to make sure that you have all that evidence ready when you are filing for the application.
Okay, so Noemi, I believe doesn't have a question anymore, but Keisha, you're allowed to speak. Go ahead if you have a question.
Okay, thank you. Hi, everybody.
Hi.
Can I go through your services through your company and get a trademark done? Do you help us with the process?
Yes, we help you with the process. Through Tzedek, we focus on helping, as I said at the beginning, low to moderate income entrepreneurs. So as part of our application, we may ask you for certain information regarding your business income and your household income. If you comply with our criteria, that is part of the services that we offer. I do have to mention, because a lot of the times clients see that as a surprise, the services that we offer for helping you register are free. However, the clients are required to pay the fees that the government charge to be able to pay for the trademark. So anything that the government charges will need to be covered by you. However, the services offered by the attorneys are free.
So should we set up a appointment, a day and time that we can come down and sit with you, or do we do it over the computer
So
online?
I share again the online application. The first step is to complete it, and then someone on the team will be in touch with you to set up a call, or if you prefer to meet in person, we can meet in person too, whatever works best for you. Okay, and then people are asking what is the specific amount. So we don't share publicly all the amounts because sometimes we work on a case-by-case basis. Veronica has access to the amount, so they can help you go through different questions, or just reach out to us directly filling out the application. And once we review it, we will let you know whether you qualify or not, and why will you not qualify, and what, like, yeah, answer any questions that you may have. But publicly, we don't put the numbers for everyone to see. I'm sorry, Lita, I think is your name. Okay, I'm gonna go then to the next section regarding copyright, because we still have three more sections to go.
Nadia, I don't know
So
sure if you answered this question. What if a business has a similar name but in a different industry?
okay, so yeah, I didn't answer that one. So for that question, it will depend on whether that business is actually like has the registration only on a different class. So sometimes I would say bigger companies decide to make a registration in all the classes. For example, Apple, you will see that Apple has their main classes, of course, are like computers, phones, and other electronics. However, they are registered also under like shirts and other different products, because they want to have the availability of expand their business as they want. Regularly, business just register under one class. If the business is in a different class than yours, then you are okay, good to go, and it wouldn't affect your application. However, if that business has been there before and you see that they are also registering your class because maybe they were trying to expand their business or something like that, then you might not be able to apply. But to answer in general terms, if they are not registered under your class, you might be able to apply and go ahead and register. Okay, I don't see any other questions. Okay, so I am gonna go ahead and move to copyright law. So copyright protects original works that are fixed, or that are basically is like established or written in a specific tangible medium. The purpose is encourage the creation of works, and copyright is usually very relevant for artists, because the types of materials that are protected under copyright law include books, songs, pictures, and other graphics that usually artists are able to do. The term to be able to protect a copyright includes the life of the author plus 70 years. And if you are a corporate author anonymous, it can be 95 years from publication. But usually, if you are going ahead and you're a known actor that is wanting to register, then you can go ahead, then it will be the first part, known actor plus 70 years. And what does publication, what is the meaning of publication? The distribution of or offering to distribute copies of the work to the public sale or other transfer of ownership. That means that is considered publication in case you are a corporate author or you're anonymous. That's starting when the publication, the term for your copyright will be protected. Let's go to the next one. So what are the requirements for copyright registration? So the first is, as with the trademarks, that you are actually that is original and it is different. So it's distinctive originality that is independently created by the author. So it means that you cannot include in your specific creation or work something that is a copy of someone else's creation. Creativity, as I said, it is important that you are original, creative, and that is something different to that you want to protect. As it says there, a phone book is not sufficiently creative, so it wouldn't be able to be registered under copyright. And then the most important part is that it's fixated. So we see people that say, and we were talking about NDAs a little bit at the beginning of the presentation, that they have these ideas and they start sharing it with other people. You start like telling your family and friends that you have this idea about this book. But if you hadn't actually reading the book, then it is not something that can be protected. It is very important that it's actually fixated in something that can be perceived or communicated. So it's actually in writing or put it in a, as I said, fixated in something to make sure that it actually can be protected. And then what types of works can be protected? So as I said, books, poetry, music works, lyrics and music, plays, photographs, drawings, paintings, sound recordings, and architectural works, including like blueprints and renderings. So a lot of these things are what are considered works created by artists. And then what else copyright protects? So it actually protects that idea of expression, that idea or expression that is in that specific paper, but it doesn't protect the idea. It's only what is actually in paper, what is actually being protected. The copyright doesn't protect an investment of time or effort. It is, as I said, what is in the paper, what is being protected, and it has to be an independent creation. If created independently, two or more works may be similar without one infringing. So what that means is that if it is created separately, then actually can be protected if you are not infringing someone else's intellectual property. And as with trademarks, sorry, when I go the last one, sorry. So as with trademarks, it is not a requirement to register under copyright, because once it is written in a paper and you have a way to prove that it was there and that it is your actually your specific creation, then that is considered yours. However, there are certain protections granted by copyright that protection, like, and those protections only exist if you actually register the copyright. So as it says there, the protection arises at the moment of fixation, and it gives exclusive right to reproduce, create derivative works. Derivative works are like something that is like, I would say you have a main novel and then you create a sequel of that, or a part of that that is considered derivative, distribute copies, and show the work to the public. But registration is not required, as I said, to have a valid copyright. However, registering gives you the right to sue in case someone is actually infringing your copyright, and you may be able to get statutory damages, which is damages that you can get if somebody copies your intellectual property. So it is important to know that by having the copyright already fixated, that will be already considered yours. But to be able to sue someone for copying your copyright, then you need to go ahead and register. Then we're gonna move to patents. So I don't know if in these sections on copyright anyone has questions.
There was a question in the Q&A. So what if
Uh-huh.
Apple does not intend to use the trademark for furniture? Can they still file a trademark in that category of furniture?
They will need to prove that they are in the process of actually using it. So part of the requirements of registering the trademark, and we already, that's part of the last portion, is to prove that you are using the product, or like that you are using the name in that area. So that's why, for example, with sweatshirts, sometimes they actually have to like show that they are selling that there is available and everything because they are using it. If they are not gonna use it and they don't have a way to prove that they are using it, then it might be declined. Like they might not be able to get it. Okay. Any other questions regarding copyright? Okay, I'm gonna go ahead and move to the next one, which is patents. And I will say, as I start with patents, that we been sending clients to the LA Central Library. The LA Central Library has now once per month attorneys coming to the LA Library helping inventors with questions regarding patents. It's something important to mention too, that for us as attorneys, you need to have kind of like a separate license to be able to work on their and register patents, because the process can be very complicated and might require that the attorney helping you has some background knowledge on, I don't know, engineering or medicine, like science or other areas that a regular attorney may not have. So I would suggest everyone that has ideas regarding patents and that they want to register a patent to reach out to the LA Library because of the great resources that they have available. I actually received an email and the next day that the library will have attorneys there. I think it's May 7th. So I'm happy to share the flyer with you, Veronica, in case anyone has questions about patents. So a patent gives the owner the exclusive right, the owner the right to exclude others from making, using, offering to sell, selling, or importing the specific invention that they have within or into the United States. And the term of utility of an utility patent is from the date of issuance plus 20 years from the date of filing. So I will say that one of the most common examples regarding patents is like a medicine. Once it is patented, nobody can use that specific formula to create that medicine than the company that is registering it. However, after 20 years, the government has established that patent becomes from public use. So everyone can actually go ahead and start making that recreate that formula for that medicine, or in other words, they might be able to start using that patent for the public benefit. As with trademarks, there are different sites in which you can actually look to see if the patent is available. The one that the LA Library recommends and that we think is a good resource is the Google Patents. So in Google Patents, you can do the same type of search that you will do on the USPTO for a trademark, or in Google for any word that you may want to search the meaning for to see if the patent is available. So what do patents protect? The patents protect, as we said before, inventions. And what are the requirements for patentability? Again, novelty, as we saw before, uniqueness for copyright, or that distinctiveness for trademarks. With patents, it is called novelty. Something that is not obvious, that is adequate for disclosure, and that is the utility that they may have. So Mary already put the link to Veronica put the link to Google Patents, which I think is a great resource, as I said. So obtaining a US patent. So you may have the invention, and then you have the conception and the reduction to practice. You basically have to create a step-by-step process of how you are getting that process going or happening. And it may include different, I'm gonna go ahead to show you. Oh, I didn't include a picture here. I usually do, but I'm happy to show so if you go to Google Patents and you start looking for them, you will see that sometimes they have specific pictures and very detailed steps on how you are following that process to make sure that you are able to protect it. So you need to, first of all, create a note of declaration where you are saying that what you're creating is yours. You may have to pay some fees. As I said before, through the program, we're able to find attorneys that sometimes are able to help you with the patent process. However, any fees implicated with that process you need to be covered by you. And then, as I was explaining, you need to have a writing description and drawings of the process that you are trying to patent. And any specific claims is like specific things that are different in your process than in other processes that might already be available. The other thing that I will mention with patents, because I think this is one of the areas where a lot of people may share information without having NDAs, is that if you are running your patent through someone, I remember we had a community event and somebody was saying that they were a construction worker and they actually had invented something to be able to put the floor as part of the construction in a very innovative way. They shared that with other people on their team, and they never use any documents, as we had said before, an NDA or any type of agreement, and then somebody else stole the patent. So as if you're in the process or you are interested in creating a patent or registering a patent, it is important that you have the appropriate agreements. And then those are the different patents that are available: utility patents, design patents, and plant patents. I would say the most common for the types of businesses that come through the program are utility patents, which protects new or improved products, processes, or machines. And design patents, they protect new, original, and ornamental design for an article or manufacturer. And on those, imagine specific designs, for example, for the bottle of a beverage that is very innovative and different, they want to be protected. Like that specific design want to be protected, and that can be a design patent. Okay. Any questions regarding patents before we move to trade secrets? Nope.
No, none at this time.
Okay. So we are gonna go ahead now with trade secrets, and I will say that the most common example and the best kept secret in the world is probably the Coca-Cola recipe. So we just saw that with patents, the process, like the steps that they follow, for example, to create Coca-Cola, if they were to patent it, it just lasts 20 years, but then after that, it becomes from public use. And then you wouldn't want to have, like, I remember we had a client that had specific recipes that where, like, I think were coming from her family, and she was like, I think I want to register them under copyright. And I was like, well, why would you register them under copyright? Like, are you planning to like sell a book with your recipes? Then everyone will know how the recipes are done. So that wasn't also the most appropriate way to protect them. So a trade secret must be something that derives economic value from not being generally known, or for people not knowing what it contains or what is the process for that. So, for example, with Coca-Cola, all like there are sources that say that nobody has the full recipe of Coca-Cola. They had been able to keep it as a trade secret for many, many years because they had divided the recipe. People in different places have parts of the recipe. And the most important, we already been talking a lot about it, is that they have NDAs with anyone involved in the process to make sure that they don't disclose information. So some common types of trade secrets include customer lists, training methods, business strategies, formulas, recipes. And what that means is that you are taking all the steps to make sure that that is kept as a secret and that nobody else has access to the specific information that you want to protect. So what are the benefits of keeping something as a trade secret and not registering or there? One of the areas, other areas of intellectual property that we saw. So trade secrets can cover abstract ideas and patents do not. A trade secret protection is available even for information that doesn't meet a lot of like some of the requirements of novelty or patentability that other of the intellectual property forms that we saw have. And the trade secret protection might be cheaper and easier to obtain than patent protection or other types of protection. And as we had said, the benefits of keeping something as a trade secret is that they can last immediately, like indefinitely. It wouldn't have that term that the patents do, for example. And that's the last part for patents. So I don't know if anyone, sorry, for trade secrets. I don't know if anyone has questions around it. No?
No, I don't see any.
Okay, so here are some of the key takeaways. So your creations might be intellectual property. if you are in the process of, for example, starting a business and you are thinking about different brand names or logos, and you want to make sure that before you invest resources and time in creating an amazing marketing plan, start posting on social media and everything, you make sure that those are available and that they are different, and maybe consider patenting or doing the copyright or the trademark for any specific creation that you may have that might be intellectual property. It is important to protect your intellectual property, as we saw, even though for some of them it is not a requirement, because you may have the protection, since they are, for example, fixated as copyright. It gives you some rights that you don't have if you don't register. And the other important part is to take action after you have registered your intellectual property, to make sure that you are on the lookout to see if anyone else is using it, that you follow the appropriate steps to be able to continue protecting your intellectual property and that nobody else is using it. So that's it. Here is our application for assistance again and the resources that we have available. And I'm happy to answer any other questions that people may have.
Okay. Thank you, Nadia, for just a wonderful presentation. There is a lot of information. So I really want to encourage people to, if you have an opportunity to either rewatch the presentation to get more of the information, or of course, click on the link so that you can go ahead and register. And so how long usually should they expect to get a callback after they've completed the intake form?
Yeah, so it usually takes between 4 to 5 days to hear back from us. We try to do it before that, but yeah, once you fill out, yeah.
Okay, perfect.
Somebody says that they didn't understand me. I'm sorry, I'm a little bit sick. You can reach out if you have other questions. And then somebody asked whether they can use the service if they are in Santa Monica. Yes, we cover all LA County, so you can reach out to us if you're in Santa Monica.
So I know you mentioned a few times the fees, but you didn't give specific price. Are there not a specific fee? Is it just vary, or what's
So
the
every
range?
year they publish the different fees for each of the different areas that we discuss. So we don't include it in the presentation just because it varies it may vary with time. And as I said, if you are registering, for example, a trademark only under one class, the price is different than if you are registering under different classes. I'm happy also to include as part of the presentation, there's really good resources on the USPTO website where you can get access to the fees so you have an idea. I'm happy to share that link with you, Veronica, as you follow up with the PowerPoint too, so you include that.
Okay, great.
Okay.
Okay. So right now we don't have any questions, but I do encourage everyone. I usually do share our contact information in the email that I will send, and I also include the information for you to go ahead and schedule the appointment. So yeah, so since we don't have any questions, we'll give you 4 minutes back. And thank you, everyone. We have a lot of thank you, Nadia. So thank you again for
Thank
your
you.
presentation. And like I mentioned, we will see you all back here on May 20th for business entity formation. So if you started your business entity or you haven't, or maybe you already have and just want to get clarification, that'd be great. Please join us roughly a little bit under a month so you can get the full series. So thank you everyone for